Today we're going to continue talking about ADEA, the Age Discrimination and Employment Act, which is Chapter 6 in the textbook. So my estimation is that we've already talked generally about this law, and we have talked in class a little more specifically about the disparate treatment and disparate impact types of cases. So with this, we're going to start with the hostile work environment type of claim. So all of this hopefully has been sounding a little bit familiar to you, since it's not very different from the Title VII types of claims. It's just obviously focused on age. So to bring a hostile work environment claim, have to be able to show that the plaintiff is at least 40 years of age or older. The harassment itself must be age related in some way, shape, or form. The has to be unwelcome, offensive, and pervasive. So the same hostile work environment standard that we've talked about in all the other types of cases. And just like in the other types of cases, it must create an objectively intimidating, hostile, or offensive work environment. So there has to be an impact or an interference with the work performance. So just like hostile work environment cases under Title VII, especially with sex discrimination that we discussed, there is no adverse employment action. The hostile work environment that is created in and of itself is the harm, and that is what we have to show. Also notice the language objectively. So again, we talked about the reasonable person standard, and that's really what you're looking at in this situation as well, as a reasonable person standard. So, so those are the initial burden. The other part that the employee would have to show, which is also important and should sound very familiar to you, is that the employer knows or should have known about the harassment and failed to take prompt and effective action. Okay, I'm going to say that again. The employer knew or should have known about the harassment and failed to take prompt and effective action. So again, we don't have quite the same law as we do with the sex discrimination about how the employer is supposed to have policies and procedures. But obviously, if the employer does have reporting policies and procedures, we would like this ADEA, hostile work environment plaintiff or employee, to notify the employer through those proper channels. It is not as imperative as it is with the sex discrimination case, but it still makes for a much stronger case, because if the employer knows and fixes the problem, then there is no case. It's resolved, and that's a good thing. Or if the employer knows and fails to fix the problem, that allows this employee to have a much stronger case going into court to try to get resolution of the issue that way, or to try to get resolution of the issue through the administrative process. So again, should all sound very familiar to you. There was a case, just by example, where you had a circuit court finding that a small number of poorly chosen comments do not necessarily create a hostile work environment. So again, we have a little bit of the same issue that we had before when we're trying to figure out where is that line where it truly becomes pervasive. So in this particular case, which came out of the Sixth Circuit federal court system, some of the comments made were old people should be seen and not heard, and women over 55 should not be working. So in that case, an employee brought a ADA hostile work environment claim, and the court found that it was overall a small number of poorly chosen comments, and that did not necessarily create a hostile work environment. So again, we need to look at the types of comments that are made, how frequently they're made, the context in which they're made, to try to figure out objectively if it truly is a hostile work environment. Another thing to keep in mind is that age-related comments generally will carry more weight if made by a person who was involved in the employment decision. So whether it's a hostile work environment or disparate impact, disparate treatment, if it's made by a supervisor, a manager, someone up the chain of command, those comments may carry more weight in terms of determining if it is an ADEA violation than if it was, for instance, a coworker. So Some types of comments that have successfully supported age bias claims in the past, that younger blood is desired. You're too old to learn anything new. Get rid of old gals and get some young gals in here. Which sounds like it's from a very old case. And this one, you can tell things have changed because here's where baby boomers were still the young people in the office. Older people don't like us baby boomers, but there isn't much they can do about it. So the comments are important. What we have to try to figure out if we are um, representing the employee in these cases is who is making these comments, how often they were made, is it a hostile work environment case, or do these comments potentially support a pretext argument for a disparate treatment case? So, for instance, you have an employee who suffered an adverse employment action and they believe it's based on age, and we're trying to figure out how to prove that. And the employer comes in and shows a seemingly legitimate business reason. These types of comments might show pretext. And again, just a reminder on pretext. Pretext is basically it's a cover up for the real legitimate reason or the real reason that the employer made the decision. So the employer provides what appears to be a legitimate reason for the employment decision, but you have these age-related comments that can prove pretext. So we have to get a lot of the details of what is said, how often it's said, who is saying it, and that will give us a much better idea of the strength of our ADEA claim. Okay. Next thing, next thing we want to talk about is the ADA and the hiring process. So just like when we talked about Title VII, it protects employees in all phases of the employment relationship from the hiring process itself, the advertising hiring process to retirement benefits post-employment. So same thing with ADEA. So how does the ADEA specifically impact employers in terms of how they hire employees? The most obvious one is that the ADEA prohibits employment notices from including any preference, limitation, specification, and discrimination based on age. Now, there are a few exceptions to that we'll talk about in just a second. But the employment postings, the job postings itself should not say anything about looking for younger blood or want young, high energy. Sometimes you get these euphemisms used. Employers have to be really careful that they're not putting anything out there that is showing a preference or limitation on age. So I know back in the day seeing postings that would say things like rock and roll atmosphere type of thing, which obviously at that time they weren't trying to attract people of a certain age. They were trying to attract younger workers. And so not that that in and of itself would be discrimination, but it potentially could be a piece of a case of discrimination. And so employers need to be very careful about how they write their postings. It's one thing to want or need somebody with a high level of energy or a certain skill set or a certain strength level or stamina level if that's necessary to do the job. But again, the employer needs to make sure that they are requesting qualifications based on the skill level to do the job and not on age. So similar to what we talked about with sex discrimination and wanting employees to be a certain height and weight, that wasn't what was important. It was what they could lift. And so it would be the same type of thing with ADEA claims. You want employers to avoid those claims by making sure that they are focusing their job postings and their requirements on actual skills and qualifications. Having said all that, it is completely appropriate and not an ADEA violation for employers to request information that will actually indicate the employee's or the applicant's age. So, for instance, it is okay to ask for date of birth on job applications, even though obviously it could be much clearer on if somebody would be 40 and over by asking that information. They can also ask about work history, salary history, and those types of questions where employers can figure out how old someone is. That is not a problem because that there is a certain relevance to all that information. However, and this is where it can be a little tricky, employers should not factor that information, meaning that the age of the employee, into the employment decision. And so, just asking for a date of birth on a job application is not an ADEA violation. However, if the party can prove that age was okay, I'm sorry about that. It's Monday afternoon. It's a really nice sunny afternoon. Everybody's walking by, and it's just driving my dogs a little bit crazy. So I will try to eliminate as much barking as I can, but please just bear with me. Anyway, if an employee can prove that age is a factor in an employment decision, they can still be successful in a claim, but they have to prove more than just the fact that the employer asked for a date of birth. Another thing employers should be aware of is using certain terms such as overqualified. There is a case that came out of the Fifth Circuit Court, Federal Circuit, that basically said that this word, overqualified, can be, again, sorry about that. Anyway, Fifth Circuit Court said that a word such as overqualified can basically be code for too old. So employers need to be careful when they reject an applicant if they give a reason, and we'll talk about why maybe employers shouldn't give a reason, but if they give a reason, to be careful not to use words like overqualified if there is enough information there that would lead an applicant to think it's not that they're overqualified, is that they are just too old. Basically, what the Fifth Circuit Court said is it is up to the employer to determine who is the best fit for the job. They do not have to be the most qualified to be hired, but the employer has to show that they are an appropriate fit. And there can be a legitimate concern that if you hire someone who has a skill level above what you need, that they may be bored, they may leave soon, it may not be a good fit for them. So it's not that the idea of someone truly being a bad fit is a problem. It's just how that is conveyed to that employee. Overqualified can be a problematic term to use with the applicant. A lot of times what you will find, and some of you may have seen this in your own experience, is that employers will not give reasons why someone is not hired. And there's a variety of reasons for that, but this is one of them, that the employer is going to inadvertently say something that is going to give rise to a claim. You're too experienced. We're looking for someone who is fresher. We're looking for someone with more energy. These terms that can be interpreted to be age-related claims. So we would want to advise our employer clients to stay away from those types of terms, to either not give this information to applicants to begin with, but if they're going to give feedback on why someone is not hired, to focus strictly on the qualifications and skills and not kind of get into these terms. And overqualified is one of those words that people can use that makes it sound like I'm being really complimentary to you. You're just too good for this job. And so it makes the employer potentially feel a little bit better in using it, but it can sometimes end up being used against the employer as code for you were older than what we wanted to hire.